Ladies and gentlemen, we're going to be starting shortly.
As in right now. So welcome everyone to the State of the Unions panel, What's Next for Organized Labor. My name is Dorian Warren. Let me make three quick announcements you've probably heard already in other sessions. First, please silence your cell phones. That's for audience members and panelists, I might add, since we are video recording this session. Secondly, for those of you that are social media savvy, if you would like to tweet anything you hear, of course with permission of the panelists, if you would like to tweet anything you hear on this panel, the Twitter handle for ACS is @ACS Law, and the official hashtag is #ACS16. So please include the hashtag as you tweet the provocative and fascinating things you're going to hear from this esteemed panel. Last but not least, please be advised that there is CLE credit, and that information can be found online for this session. All right? So we have a fantastic lineup of folks to talk to us about the future of organized labor, especially in light of the Friedrichs decision at the Supreme Court. And I just want to start quickly by saying who they are in the order they're going to talk to you for about 5 minutes with some opening remarks. I have some framing remarks, and then we'll have a facilitated discussion before we go to Q&A. So we'll first hear from Ruben Garcia, who's professor of law at the William S. Boyd School of Law at the University of Nevada, Las Vegas. Following Ruben will be Judy Scott, the general counsel at the Service Employees International Union and a partner at James & Hoffman. Following Judy will be Richard Griffin Jr., who is the general counsel at the National Labor Relations Board. And last but not least, we'll hear from Dan DeSalvo, senior fellow at the Manhattan Institute and an associate professor of political science at the Colin Powell School for Civic and Global Leadership at the City College of New York, CUNY. Long, long title. So let me first just say three quick things to help frame the discussion. So I'm going to go big picture. If we think about the role of workers in the economy over time, I don't know, 200 or 300 years. We know that there are incredible crises of inequality during major political economic transitions. So at the birth of our capitalist market democracy and economy here, our response was, in a sense, Jacksonian democracy, extending the vote, providing some, not many, labor protections. But the transition we're really concerned with here is the transition of our economy from an agricultural economy to an industrial economy in the 19th and, of course, early 20th centuries. And our response to that was the framework that we've been operating with for the last 80 years. Essentially, the New Deal was the response to that painful transition to an industrial economy. And obviously, the birth of the Wagner Act, followed later on by the wave of public employee rights around organizing and bargaining. And then, of course, this is point number two, we have been living through, in the last 30 years, the breakdown of that mid-20th century industrial labor relations regime and transitioning to an economy that has lots of different names that people throw out that we're going to talk much more about. Some people say we've gone from an industrial to a digital economy or a service economy, and now the hip thing is, of course, the gig economy or the 1099 economy. And it raises all sorts of issues, including, of course, the prevalence of low-wage work as opposed to middle-wage work. Of course, claims about the legal status of workers versus independent contractors. I think we're going to talk a lot about that today. And then what our friend and colleague over at the Department of Labor, David Weil, calls the fissured or the fissuring workplace, the rise of subcontracting, outsourcing, misclassification. Essentially, the traditional employer-employee relationship has in many ways broken down from how we understood it at the mid-20th century. Last point, and that is just to do some fear-mongering in the room, to be provocative. There's a lot of talk, and this reminds me of discussions, and I'm looking at Judy because she worked at the United Auto Workers for many years, discussions in the 60s around automation. There's a lot of talk about automation. And so we're having that same discussion right now around technology, and instead, and here's the fear-mongering part, the robots are coming. How are we going to regulate robots? I don't know. So those are just three broad points about the crises of inequality in terms of major transitions in the nature of the economy, the breakdown of the 20th century industrial relations regime, and the range of questions, and in particular legal questions that arise from the breakdown of that traditional employment relationship. And then hopefully maybe we can get to some questions about technology and how should we be thinking about the next 10 to 20 years, which in fact SEIU has done a lot of thinking about. So with that, I'm going to turn it over to Ruben Garcia, who is going to provide us with 3 provocative theses about some of the most important issues facing the labor movement and workers today. So Ruben.
Thank you. I'm very happy to be here. I tried to come up with sort of a top 5 list, sort of a high-fidelity list of all the big issues in labor right now, but I couldn't come up with just 5. So I tried to wrap that then into three big themes, I think, that are, face the state of the unions right now. The first, of course, and I think, again, they incorporate some of the things that Dorian has talked about, and I think the other panelists are going to talk about as well. So the first big theme, of course, is the Supreme Court, or stalemate at the Supreme Court, or deadlock at the Supreme Court, however you like to think about it. Now, if you studied labor law, you know that there haven't been a lot of Supreme Court cases, private sector Supreme Court cases lately, because, for one, the Supreme Court, in many people's view, has killed all the good labor law in the last 80 years. And so there's a big debate. There's always been a big question about, what we can do with the Supreme Court to further the labor movement, and that, of course, is also a function of the Supreme Court taking so few cases, and so that is we've only seen really 2 or 3 private sector labor law cases in the last few years. Where we've seen the most cases, however, is in the public sector, and I'm going to talk about in a second how I think these 2 themes are related. In other words, the trilogy of cases against the public sector labor laws in Illinois and in California, and of course the most recent Friedrichs versus CTA non-decision, I think, as we will see. And so these cases, of course, are under the First Amendment, and they are challenging different aspects of public sector labor law. And I think, again, they also are going right at the idea of that's where, and I think Dan will talk about this as well, the idea that's where the real growth is. That's where the growth has been in labor in the last several decades. So again, these cases, Knox versus SEIU, Harris versus Quinn, and most recently Friedrichs versus California Teachers Association, they challenge the First Amendment rights, or the First Amendment laws that they said negatively impacted the rights of dissenters. So the death of Justice Scalia, of course, as we might expect, really put the brakes on the Friedrichs decision. I think it's as those who read the tea leaves on SCOTUS blog or other Supreme Court cases, I think it's pretty clear that there was a majority for striking down the California agency fee law under the First Amendment until the death of Justice Scalia. So that, of course, in a deadlocked Supreme Court situation, that raises all kinds of questions about who the Ninth Justice will be, when the Ninth Justice will take the seat. And so that, of course, raises a lot of questions for the state of labor and the strategies and I'll talk about in a second, the positive strategies there might be for the labor movement in the courts. Just briefly, of course, the main action also in the Supreme Court has to do with the Fair Labor Standards Act of 1938. And so that is, again, something that I think the other panelists will touch on. But there you see a lot of limitations on the statute in recent Supreme Court cases, particularly in terms of overtime. And again, that ties into a second theme that I think comes up in this discussion, which is the role of administrative agencies in making labor law. So the real challenge, or the real mission, it seems, to many people, is that there are certain elements in society now that are trying to deregulate the workplace through the First Amendment. They're trying to deregulate the Wagner Act model. So again, as you might know, the First Amendment does not directly apply to the private sector workplace, but the Wagner Act model of exclusive representation in large bargaining units to increase the leverage and bargaining power of workers is the model that was imported into the public sector. Right, and so that model is under attack. Right, the First Amendment cases of Friedrichs and Harris versus Quinn are really getting at that idea of really trying to destabilize and deconstruct the Wagner Act model that gives workers more bargaining power in exclusive bargaining units. And so that is again, the agenda that is not just in the public sector, but as we might hear today, also coming through in the private sector, in other words, challenging the constitutionality even of exclusive representation. So I think we'll hear a little bit about that. And then the final theme, I think, that we've seen in the last few years is, of course, what happens in divided government, the swinging administrative pendulum, right? And so you have the NLRB and the EEOC trying to craft policy to bring these laws from the 20th century into the 21st century, and you have the pushback through the Constitution and through the Congress, of course, to try and stop it. And so I know that the General Counsel will talk about what the NLRB is doing in this regard, but the recent actions of the DOL on overtime and the persuader rule, which is a rule that requires employers to disclose the expenditures and contracts of entities that they use to persuade their employees not to engage in collective bargaining. Those kinds of initiatives by the Department of Labor are also under attack. And so that is, again, part of what happens in a divided government kind of situation. So again, I think everyone, especially after last night, is probably very focused on the presidential election and focused on what happens there. But I think as the last 8 years show, what's really almost more important is who controls Congress, right? And so you see, if we have a president, a Democratic president, then we're going to see a lot more of the same in the next 8 years or the next 4 years that we have in the last 8 years, unless there's some significant change in Congress. And so again, I think that's something that we will have to think about if we're going to talk about a wish list of labor law reform or even a defensive posture in terms of the next 4 or 8 years. So thank you.
Great. Thank you, Ruben. Judy Scott.
Well, I am really pleased to be here because for me, I graduated in 1974, so I'm looking back over 40 years of practicing labor law and saying to myself and seeing and watching what's going on now, that we are in a wonderful time for workers and the rebirth of the labor movement. This is a very hopeful time, and I want to lay out why I feel that way and why I feel it's so wonderful to see lawyers who are in training now, who are going to be coming out at a time where you can really make a huge difference in this role. First of all, the rebirth of the right to strike, a fundamental right in this country that was enacted in the National Labor Relations Act, that was torn apart over the years by setbacks in the right of private sector workers to strike, because they were told they could be permanently replaced, and the PACO situation, which gave people sort of a gloom and doom about the right to strike. But now we have the emergence of the Fight for 15, the fast food workers, and we've seen since 2012, when in November of 2012, workers walked out of fast food establishments in New York City, maybe 200 of them at that time, spread now over the years to the fact that in April of this year, we had thousands of workers in 300 cities across the United States, in 30 countries in solidarity actions on 6 continents, striking in solidarity with each other about the right to a $15 an hour wage and the right to form a union without retaliation. And to me, the fact that this is happening and that people are listening and that workers, it's building in a movement, is an incredibly important sign that we are going back to fundamental rights of human rights in this country. That is the right of workers to engage in collective action, and people are taking it into their, taking the courageous step, and they're making a difference. I've learned over time watching in these movements that people, a lot of times we would say, when things get really bad, people are going to get into the streets and make a change. And you know what? People don't do that unless there's hope that what they are doing is going to make a difference. And when you have hope, people take action because they know there will be results. And when there are results, people take more action. And that's what's happening when you watch this fight for 15. Started in 2012, people walked out, and all of a sudden, 4 years later, you are seeing statutes, wage increases being passed in, LA, in Seattle, in SeaTac, in New York City, in New York State, in the southern cities, where people are changing the law to increase the minimum wage and to say there is a really incredible gap in income equality in this country, and we have to do something about it. And so, to me, that has been a really exciting development. You match that up with a second thing, and that is open source activism, which wasn't there for us in the past in movements. And now we have situations where we might send supporters. The SEIU has been very involved in supporting the fast food workers movement and the Fight for 15, which has spread that movement to other workers. But we didn't send organizers into small cities in Arkansas. And all of a sudden, we would get calls on the day of the action, and hey, I'm on strike, what do I do now? And this is because people were getting on the internet and downloading. Now we have the right to strike in a box, where you can download the materials and look at your own workplace, see if it's consistent, and you can take advantage of tools we didn't have the ability to do to make this movement much broader than it originally was. Third is the notion of what is collective bargaining. We have been, as Ruben said, constrained in a law that started in 1935 and spread through industries. You had the auto organizing across the industry, steel, mine workers, but then it started getting more and more constricted to the only having your right at the work site and having to fight in a battle in such conflict when workers wanted to access collective bargaining that they had to do it work site by work site in battle with an employer who had a lot of economic tools on its side of the equation. Now we're starting to see the concept that I would say bargaining on the common green, which is tripartite bargaining, which you might have seen in Europe or Australia, in other countries, but it's a concept that workers don't have to be restricted to a small collective bargaining table at their work site. We can have something where you have the government involved with the industry, and a very good example of this is what happened in New York with the Fast Food Wage Board. Now, that was a statute that was passed in, I think 1937. And it had been on the books in New York State, and there are about 8 other states with comparable statutes where you could call for a wage board that would look at a particular occupation and decide whether or not there should be a minimum wage rate set for that occupation. So not a statute, but a board. In this case, Governor Cuomo actually responded to workers in the street, called for a wage board on fast food, which had a union representative, a corporate representative, and a mayor of Buffalo. And they got together in May. It was called and convened in May of 2015, and they had a decision by the summer calling for $15 an hour to go into effect for the fast food chains in New York State. Now, those were not just workers being in the streets causing the wage board to be convened, but then they actually were appearing as witnesses in 4 public hearings that were around the state. 250 people testified from all walks of life to talk about what it means to do this kind of work, and employers coming to talk about what it would mean for them. And so you had really bargaining going on in a public arena that ultimately resulted in a finding. And yesterday, this finding was challenged by the National Realtors Association. And yesterday, the New York Supreme Court Appellate Court ruled in favor of upholding that wage board decision. And I loved it. The Constitutional Obligations Panel was talking this morning about dignity and the concept of dignity. And in holding that this wage board decision should be upheld, the court said one of the challenges was this work wasn't really owed $15 an hour. It wasn't of that much value. And they said, as for the value of work performed, fast food workers spoke to the difficulty of the work, multiple tasks over irregular hours for employers who had little concern for the dignity of their employees or the environment in which they worked. The Wage Board further noted that fast food chains had recently experienced significant increases in profits without an accompanied rise in wages for their workers, implying that those profits were wrung from the necessities of their employees by undervaluing their labor. Now, this is written in today. I thought this might be a 1937, court decision, but this is today. This is why things are happening, and so I would say one last thing. I'm probably going over my time, but the fourth thing that is so wonderful is we are having a confluence of movements in a way that wasn't happening. When I walked out of law school in '74, we had the women's movement, the anti-war movement, the civil rights movement, very much, the momentum of us all working together. Now we have a convergence of movements again. Black Lives Matter, the environmental justice movement, the immigrant justice movement, LGBT movement. And you know what? We have all started to recognize those movements are each of our movements. The fast food worker and the Fight for 15 movement is just as has to be embedded and supportive of these other movements. And they are key, and we're going to be behind each other in having each other's back and in litigating with each other. We're very much involved in the DAPA defense, the labor movement. We have just recently filed on the support of the clean energy plan, clean power plan, in support of President Obama's plan. And, in so many ways, in Black Lives Matter, we have been very much involved in the racial justice movement and those issues. So that says there's a force way beyond, what we have had behind the wind at our backs that we haven't had before. And so for me, it's a hopeful time, and I think the future of workers in the labor movement is going to be great. So.
Thanks, Judy. That was so not what I was expecting you to say. And especially, I thought you were going to depress us, actually. So thank you for being hopeful. And for the younger folks, do not fear. You will still have strong employment prospects, even if we can download how to strike from the web. Just want to assure everybody. Dick Griffin.
I want to pick up on a couple of the points that Judy made and discuss the challenges for the primary federal agency charged with enforcing the primary law governing labor management relations, responding to the types of activities that Judy described. And I'm going to talk briefly about the Fight for 15 cases and also some cases that we have that were brought by the UFCW and our Walmart as part of a sort of similar effort that's going on at Walmart. And it seems to me these cases present sort of two challenges. The first is a doctrinal challenge. As Judy mentioned, the National Labor Relations Act has been around since 1935 and has arguably not necessarily always been sufficiently flexible to accommodate the types of activities that workers have engaged in, and also the interpretation of the act has been limited significantly, as was pointed out by the Supreme Court. Just as an aside, as a constitutionally challenged recess-appointed former board member whose status was declared unconstitutional in a private sector case that the Supreme Court did take, I sort of take the point that it's not always the best idea to end up there. But specifically with respect to the doctrinal challenge, the way I look at the Fight for 15 and the our Walmart cases, it's really, in a way, if you want to kind of pigeonhole it under the National Labor Relations Act and its categories, it's kind of like a national area standards campaign. It doesn't have an immediate recognitional objective. It has the objective of establishing, not protecting, area standards in the areas of wages and standardized hours. But I think it fits pretty easily within the protections contemplated by Section 7 of the National Labor Relations Act. And the judges, administrative law judges, who have heard the cases, we haven't really had a case up at the board yet, really have had no trouble finding that type of activity and the strike activity that Judy referred to is protected by Section 7. The bigger question from our standpoint really has been the logistics of handling cases that arise from a national ongoing effort. Because as a result of the reaction to both the Fight for 15 and what's going on at Walmart, there's just a steady stream of unfair labor practices that get filed, and trying to figure out how to most efficiently and effectively enforce the law in a meaningful way in those types of situations is a challenge. And so what we did, excuse me, in Walmart, and this was with respect to the strike activity that went on in terms of the trip to Walmart's headquarters. People struck, and then they went to Arkansas and did a series of actions around the primary corporate meeting there. Was we had a national complaint, and a single law judge appointed administrative law judge to hear it, and he went to 8 different cities and heard the evidence with respect to what happened to people who decided to strike, who were retaliated against, either discharged or disciplined for leaving on those days. And he had no trouble finding in a very well done 165-page decision that the activity was protected and that Walmart had violated the law by taking the action. But it was a little bit logistically complicated to have him go around to 8 different cities and hear the evidence. Similarly, in the McDonald's case that's going on now, you had hundreds of charges coming out of a number of efforts of the Fight for 15, and they were directed against franchisees and corporate McDonald's. And so the case that's proceeding now, which includes the joint employer allegation against corporate McDonald's and then separate allegations against franchisees, includes franchisees and conduct that took place in New York, Philadelphia, Chicago, Indianapolis, and a number of cities on the West Coast. So what we've done is we've consolidated those into one complaint. There's a single judge who started the trial in Manhattan and is going to proceed around the country from Manhattan to Chicago to Los Angeles unless we manage to get the case resolved before it goes all the way through the full trial. And so it is a challenge administratively, but I think when you have a national agency with regional offices and a committed central office, the challenge can be met. And so I think we are figuring out how to respond to and make sure that people's rights, when they're violated, we have an effective way to address them. The second thing I wanted to say is just to pick up on the social media aspect and to say that we have an enormous number of cases that involve people engaging in conduct over social media to try and advance their rights in the workplace, some in the context of union campaigns, some just to engage in protected concerted activity for mutual aid and protection outside the context of a labor organization. And in the Purple Communications case, the board has expanded people's rights to use employer email systems to communicate, and similarly, we have a couple of complaints going with respect to internet and other means of communication. So I'm going to stop now and give other people their opportunity.
Great. Thank you, Dick. And just a quick show of hands, everyone knows what the Fight for 15 and our Walmart is? I presumed that, Yes? No? Okay, thank you. Thank you. Okay. Now, to throw very cold water on everything that's been said, is our friend Dan, who's going to be extraordinarily provocative.
I don't know, I hope not extraordinarily, but maybe a little. It's after lunch. Not everyone's sufficiently caffeinated. I guess I'd like to pick up a little bit with the broader remarks that Dorian sort of opened, and begin just with a personal anecdote, which is that my own experience, life experience, and family history in a way tracks the trajectory of the labor movement in some respects. And so I want to say a little bit more about that, which is to say my grandfather, who was an immigrant from Sicily, was a machinist in Pittsburgh in the steel workers union, that you could say the height of the labor movement in 1955, which was when the AFL and CIO merged. About 35% of workers at that point belonged to labor unions. You could say that was really the model of what people look back to with great nostalgia, the high point of American labor. The American economy was growing rapidly. There were big corporations. It was big labor, big corporations, and big government, and things seemed to sort of work in the corporatized model that many people still have a fondness for in Germany. My father was then a union carpenter and plumber for many years, again, still in the private sector. And then I got a PhD, so this is a good Italian-American immigrant success story. And now I'm a professor at City University of New York, which in New York State is the most heavily unionized public sector state in the country. 70% of public employees in state and local government in New York belong to unions. So I'm in a union shop with all the requisite agency fee structure that's familiar to everyone. So in a sense, I caught the tail end of the rise of public sector unions, which follow a much different historical trajectory and are often lumped in together with private sector unions as if they were the same thing. I would stipulate that we should really think about them as two different kinds of organizations. They have different histories. They're subject to different laws. That is, the private sector unions are governed by federal law. Public sector unions are governed by state and local law. They don't really come into being really until the 60s and 70s, and even a state like Illinois, not till the early 80s. And they basically have been incredibly stable and resistant to any change in the economy, in part because they're in government, and once unionized, they tend to stay unionized. So about 35% of workers in the public sector across the country have been unionized really since the early 1980s. That'll change a little bit as the right-to-work laws in Wisconsin and Michigan and now West Virginia go into effect, and so that number may tick down a little bit, but it's basically hovered between 30 and 40% since that period. I don't see anything with Friedrichs probably off the table at this point really changing that dynamic in any way. So the private sector on the other side, so just to make some comparisons, is down to last year in 2015, it was 6.7%, I believe, of private sector workers belong to unions. Unlike Judy, I don't see that number changing at all. If anything, maybe it will go down if Richard is correct about the movement of a kind of questioning of exclusive representation under the First Amendment. We're moved into the private sector domain. I'm a little skeptical about that legally, but again, I'm the only non-lawyer on the panel, I think, besides Dorian, so don't take my advice on that one. The forces in society are just not there to bring private sector labor back to anything like its erstwhile glory of the 1950s and 1960s. The U.S. economy, as Dorian began to sketch out, has changed in fundamental ways. It's a service sector economy. Service sector is much, much harder to organize. So that's going to be, I would say, if anything, going forward, looking ahead 5, 10, 15 years, slow trench warfare at about the state we're in right now, which is between 10 and 12% of workers belonging to unions. If anything, you might see a slight tick down as more states pass right-to-work laws. You could imagine Missouri passing one, New Mexico. Last year, there were 20 different states, legislators at least considered right-to-work bills, even Maine and New Hampshire in the blue Northeast. So that's probably where things are headed overall in the major numbers. You could certainly say that labor today dodged a major bullet with Scalia's death. It certainly looked, I went to oral argument, and it looked to me at oral argument that it was quite clear that the conservative majority would have struck down the Abood precedent and eliminated agency fees in the public sector. So I think that's the overall story. One could go in a little more onto the private sector side and say a few things just about the fight for 15 and the overall minimum wage changes. Again, those may have some impact. I don't think that they're going to revive organized labor's membership numbers in any way. Raising the minimum wage is, an all upside policy for the left. Labor unions like it because many of their contracts are tied to what the state or federal minimum wage is. So you raise the minimum wage, that raises the wages for their workers. The left is ideologically predisposed to increasing a floor for workers. So there's pretty much no downside to this. The interest groups are in favor of it. The party Democrats are in favor of it ideologically. But I don't think that there's been nearly enough discussion on the left, at least thinking beyond that, for what might be done to address inequality and especially automation. I don't think the fight for 15 or raising the minimum wage is going to make much of a dent at all in inequality. Probably raising McDonald's workers' wages to $15 will just speed up the pace of automation. You'll have ended up in 5 to 10 years having marginally increased the wages of those remaining employees, but you have excluded another large chunk from even having jobs at all, which is probably the overall effect. If you look at like the CBO's analysis of raising the federal minimum wage from $7 to $10 over 3 years, their numbers looked at it would increase the wages for about 900,000 workers, but it would probably have this downside of effect of eliminating about 500,000 jobs. So you get a marginal benefit for a paltry number of workers total in the economy. Remember, there's about, the U.S. labor force is about 151 million workers. So we're talking about pretty much small potatoes here, even though it sounds like it's doing something, but there's just really more smoke than fire in my view. I guess I'll leave it there if that's sufficiently provocative and pessimistic, and let it kick it back to Dorian.
Thank you, Dan. So I actually want to pick up from your comments and try to spark a conversation among the panelists. I want to also give you each a chance to respond to each other and anything each other has said. But it seems to be two countervailing things happening that we've heard. An effort to deregulate labor law, whether, as Ruben pointed out, in terms of the First Amendment or a range of right-to-work efforts. There seem to be, as Dick and Judy have pointed out, efforts to re-regulate in different kinds of ways, whether it's through administrative rulemaking or, frankly, through regulation in the streets, so to speak, in terms of reviving the right to strike. And so I just want to put that on the table and ask a broader question about where all of you see the labor movement going. And Dan's initial comments reminded me, and you should Google this later, there's this very famous presidential address given by the president of the American Economics Association in 1932, I think it is, December 1932. It's published in the American Economic Association Journal, the American Economic Review, a few months later in 33. But his presidential address in 1932 is all about the death of the trade union. And it's very strong language. And he talks about how, with the rise of industrialization, trade unions are dead. There is no future for the labor movement. And then, right, by the end of the decade of when he gave that speech, we had an entirely brand new labor movement that had emerged in an entirely new model of industrial unionism, which George Bennett, the economist, couldn't foresee. So Dan is like giving us a provocation, and I know Judy's more optimistic. For all of you, though, do you see, whether it's through social media, whether it's through new kinds of organization that's not as focused on collective bargaining, do you see some innovations for which the law will take a long time to catch up to? Do you see some innovations on the horizon in terms of the labor movement, or is Dan absolutely right?
Well, I may go first? Is that okay? I have to say, first of all, you know, we have to remember this is really important not to have, not to suffer from a lack of imagination. And there are so many, as I think that was really interesting what you said, Doreen, about how the labor movement's death knell was viewed in the early 30s around agricultural change and industrialization. And now, really what we're looking at in this country is a rising service sector that is suffering from the same challenges that we had in the industrial movement, which is this work going to be valued? Where we are going, are we going to have a stable middle-class society, or are we going to have a growing gap between the rich and poor? And how do we address that? And we're going to have to address it with the same value system, but with different kinds of approaches legally and models of organization. I'm going to throw out one really interesting example, and that is home care work. Now, mainly, this is work mainly of women, people of color in this country. It was a work that was totally in the shadows and not viewed and valued as work. And yet now we're seeing it. It is one of the largest growing occupations in America, and it is incredibly valuable to our society because people, as we have an aging population, do not want to end their lives in nursing homes. Or they want to be able to stay in their homes, whether it's in an aging situation or because they confront a disability, and live with dignity in their community. And so home care work has become an incredibly essential service in our society. And how are you going to attract people into that occupation, keep them there, value them, train them? It means organizing that workforce in a way that enables people to have a stable workforce. Now, home care workers were seen as independent contractors. They were poor people taking care of poor people. And through the efforts of the labor movement and working with states in partnership, and I think that's an important issue about public sector, where a value of labor management cooperation around the quality of services, we were able to create models so that these workers could organize in their states, not through the traditional National Labor Relations Act, but through models that were set up with the state governor, either through ballot measures or executive orders. And now over 500,000 workers in the United States have the ability, have elected unions and are no longer in isolated work sites, but have an ability to join together to improve their wages, access training, and have some form of grievance to handle problems that also respect the client, who has the right to choose who they are going to have as a caretaker. And this has been an incredibly interesting model. It was challenged in Harris v. Quinn, which was a Supreme Court case that ultimately, in a 5-4 decision, the conservatives said, no, frankly, they were saying this is not work of value. Their decisions were calling these individuals quasi-public employees who, the fact that they could grieve over their paycheck, that was not really that important an issue. Now, it may not be very important to a Supreme Court judge, but it is a pretty fundamental question of whether you're being paid the right rate by the state. And that is why, having a union behind you and your ability to access is important. So I would say the need is to have creative models to approach this question, to really have the ability to go to all the workers. Carolyn Friedrichs wrote the book, Throw It Under the Bus, which talks about all the workers that are off the grid. Kate Andreas here is doing really interesting, innovative academic work about what are going to be these new models and how are we going to form bargaining. But it can happen out there. It is happening. And I think we really need to call on our imaginations and our creative legal work and not to be discouraged by people saying, well, that was then, and how the heck are we going to have a middle class now. Frankly, in the public sector, that was the access of women and people of color to the middle class, those jobs. The government was the leader in their employment practices for the private industry in many areas. And we can't lose that. So we have to figure out how to engage and have more labor management cooperation, not tear apart the vehicles in our society that provide for that through public sector bargaining or private sector bargaining.
So I just want to pick up on what Dan said in terms of the future, in terms of the private sector. I think we're all familiar with the statistics, and Dan is probably correct in terms of, not seeing levels of private sector unionization at where it was in the 50s and the mid-30s or so. But I think what was, I think is really important to remember, of course, and Judy's absolutely right in terms of new strategies, new laws would always be helpful. But I think, and Dick mentioned this briefly, I think the most important thing about the Fight for 15 strikes and the Our Walmart strikes is that people remember that there's this thing out there called concerted activity protection. And I hope everyone knows that if you're an employee in this room, you are also a beneficiary of Section 7 of the National Labor Relations Act. And that is something, again, that is an old law. It hasn't changed since 1935. It basically says employees shall have the right to self-organization, to form and join unions for their own benefit and and engage in concerted activities for other mutual aid and protection. So that broad protection is actually the font of all these, fast food strikes and these our Walmart strikes, and it hasn't changed. And it's actually still, as Dick could say, in terms of Facebook cases, in terms of social media cases, that's really key here. And I think that's the question or the answer might not be, are we going to get up to 30% in the private sector? It's, are more people going to have more power in the workplace because they know they have this protection, because they see other people doing it? And how is that going to impact, really, again, the need for a minimum wage or even just a personal, bargain that they might be able to strike with their employer. But I think the key here, of course, is the beginning of that section says employees have the right. So again, what we know from the new workplace is, of course, the misclassification or the Uberization of the workplace. And so that's a trend, of course, that the agencies are looking at and trying to deal with. But that's really the key, here in terms of this broad protection. And I think that will probably determine more in terms of whether we'll see any change sort of at the ground level rather than, a change in the minimum wage or anything like that.
I just want to pick up on, and maybe it's because I have a lack of imagination, but what I tend to do is look at the new workplace and see whether there are any old models that could be usefully adapted. And because I was a lawyer for a construction industry union for 28 years, the interesting thing about the gig economy is that it has a lot of the same characteristics as the construction industry. You work for a short period of time, you work for multiple employers, the work's intermittent, it's irregular, et cetera. And there is a model that involves multi-employer benefit plans, multi-employer training programs, hiring halls, et cetera, that could be utilized usefully, I think, if people chose to use it to try and rationalize the work in the gig economy. And the fact of the matter is that a lot of the new gig economy enterprises essentially are the functional equivalent of hiring halls. They organize a pool of people to be available to be referred out for short-term work. And so that's one thing. I agree 100% that the issue of independent contractor versus employee is a crucial issue. And both the Labor Department and we are spending a lot of time on that issue. And the problem from the National Labor Relations Act perspective is if you're an independent contractor, you do not have rights under the National Labor Relations Act. You have to be an employee. We have seen and are bringing cases now where people who are, for example, port drivers in Los Angeles, who are clearly employees, are being classified deliberately as independent contractors, in large part because the employer wants to be in a position to deprive them of their rights. And so these kind of misclassifications we're prosecuting as unfair labor practices.
Dan, I'm going to give you a chance to respond to what's been said thus far.
Sure. I guess I would say the first point is on imagination. You can only sort of look towards the future and say what are the current trends and what are the current forces at work in society, I think, to make a serious analysis. And there has been in political science and sociology, among labor historians, an ongoing, and at this point, in my view, dead as a doornail debate about whether organized labor is going to come back in membership numbers like it did in the past. And I think basically everyone concedes in some ways that we don't see any reason why it will, but we want to continue to hold out hope. We have faith that somehow people will rise up and organize, but other people have faith that the Messiah will come back. That's the kind of thing that it's
Which
not
one?
going. What?
Which one?
Take your pick. So in that sense, it's not based on an analysis. It's based on just a hope that the workers will suddenly snap and get some new consciousness, or something will happen, or there will be some massive change, some huge depression like the 30s that will really change the configuration. Of course, it's very difficult to predict those things. Social science is generally bad at predicting the future. We still pay economists a lot of money to do it. I don't know why. They're always wrong. Or if one's wrong, the other one is right, and it's a wash. So I'm not trying to predict the future, but I think based on the experience of really since the 70s, I just don't see any force or character of the economy to change things. And I guess if you look back at the heydays, and there's a lot of nostalgia. I feel it myself. I look back at the sort of you could say it's important to say white working class of the 50s and 60s of the way my father grew up and my grandfather being in the steel mills in Pittsburgh. There's a lot of nostalgia for that. Well, why did that work in part? And why was there such a middle class wage for steel factory workers, for example? Well, you had to exclude a lot of other people to create those pay premiums from the labor market. You had to exclude blacks, you had to exclude women, and you had to exclude immigrants, right? Once you exclude all three of those, if we did that, I'm sure we could come up with a middle class wage for the remaining white workers who are currently voting for Donald Trump. So that we shouldn't look back at that period with rose-colored glasses if it just was everyone had this middle-class wage and it was all hunky-dory. I guess I don't look back at it that way if I look at it seriously. So I think the better strategy looking forward is to say, rather than try to take these new industries like the gig economy, Uber, Lyft, and so on, and make them fit into these old molds, or take franchises and make them not be franchises anymore, which is trying to compress them back into an older model, is to probably not look at the labor movement for ways to do this, but to look at what kind of policies can supplement these workers, and through wage subsidies, EITC, I think, is a good place to start. That's going to help people and reward work, that's going to give them the kinds of protections. You could say in some ways Obamacare does that, around providing people health insurance, or at least if the exchanges hold up and work. And the overall trend, I think, is clear, and I guess the last thing I'd say on this is if you look cross-nationally, the United States is not an outlier here. Organized labor has declined across most all developed countries. I mean, you have to put in the caveat of the Ghent countries where labor numbers remain higher, but that's in part because social welfare benefits are often transferred through the labor union, even though many of the people who are members are no longer working in the jobs for which they originally acquired membership. So once you take that into account, France has lower unionization rates than we do. It's a pretty similar picture across the board.
So let me jump in and then give it to, because that was really interesting, and I just want to put in a plug for your former president, Andy Stern, former president of SEIU, who has a book coming out this week, I believe. And I think Dan just hinted that he's a supporter with Andy Stern of a universal basic income in some form or measure. So I just want to put that on the table since we're recording this.
Not quite yet.
But there's
to that too.
Here's an interesting thing I want to put to all of you, and then feel free to say whatever you really wanted to say. But Dan raises an interesting question, so I'm putting on my social scientist hat for a second around how we measure worker power and influence. And so maybe it occurred to me, maybe union membership and density is no longer the right or only measure. Because if I think about the concerted activity campaigns, I'm going to call them that using, what Ruben just outlined, between our Walmart and the Fight for 15, well, we've seen corporate policy change. We haven't seen a collective bargaining agreement in the traditional sense. Walmart raised wages, McDonald's parent corporation raised wages, the Gap raised, companies responded, right? And even Uber is responding through basically recognizing, giving meet and confer rights to the machinist in New York. It's not a traditional union-employer relationship, but it is something different. So I'm just wondering, are we maybe even using old frameworks to understand what's already happening, and we just haven't yet defined these new forms of worker power and influence?
I don't think this is a question of either or. Collective bargaining is going on right now. It is being very successful in certain industries, and it has a ripple effect. I think that is important to understand. When a major industry or contract is negotiated and gets an increase for that particular sector, it ripples into the non-union workforce, and because it affects the overall economics of that industry. And so I think your point, Dorian, is important, which is how do you estimate the value and power of a labor movement and the power of workers to act collectively? And I think it's important to know, and Dan, I would say maybe your assessment might have been in my darkest days, at certain periods of time in the past, I might have shared some of the bleakness about what is going on, but frankly, it's not because I have hope in the just general way. It's because I'm seeing on the ground incredible changes. The Fight for 15 has resulted in thousands of workers actually getting more money in their paychecks. And then that question has moved on to paid sick leave in local and state ordinances. And it has moved on to the whole question of flex scheduling. Issues, again, I go back to bargaining in the common green, which is the movement and workers collectively acting together have really then energized, with labor movement support, the ability to impact a much broader arena. And it's interesting to note that after Harris v. Quinn and people saying, oh my gosh, the ruling against the home care workers, within a year, 20,000 workers in Minnesota, home care workers, voted to join a union. In Pennsylvania, 10,000 workers voted to join the union, home care workers. This is because, as we say in the SEIU, no court case is going to stand in the way of workers coming together to change their lives. And frankly, it's not hope. It's hope fueled by the fact of seeing results now. And I think, I love the fact, Ruben, you raised the Section 7 and Dick reinforcing that on all the incredible work the NLRB is doing now to support the fact that, wow, in the United States of America, outside of unions, in a traditional sense, workers have the right to collectively come together to change their lives. I've been called by labor lawyers in Canada and Australia to say, how does that work? We don't have that in our countries. We have a very vibrant labor movement, but non-union workers don't have an independent right in the law to work together collectively to change their lives. And we just had a very interesting case that I think will also change dynamics a lot out of the Seventh Circuit. Lewis v. Epic Systems. Judge Diane Wood just issued a decision, contrary to other courts, that says mandatory arbitration, where it bans class actions and collective pursuit of rights, is a violation of the National Labor Relations Act. Now that, when it goes up, which it will because there's a conflict in the circuits, and we have a Supreme Court that is different next year, very different, then I realize somebody said this, and maybe it must be true, but that there hasn't been a Supreme Court with a majority of democratically appointed justices since 1968. Now, maybe that explains why I've had to come to this enthusiasm over time, because I've been functioning under the wrong Supreme Court all my life as a labor lawyer. But you all, when you move forward, you're going to have a different Supreme Court, and that Supreme Court is going to look at Lewis v. Epic Systems, and it's going to decide, you know what, they got it right. Diane Wood, who actually took the time to look at the National Labor Relations Act and parse it, and say, you know what, there's a fundamental right to engage in concerted activity. It has been read not just to be at the collective bargaining table, but to band together to work to change things. Now, that's going to be huge, and that's going to say to people, we can do things and they make a difference. We can get rid of this ridiculous concept that we can write out of the laws, the civil rights statutes, the Fair Labor Standards Act, and put people by themselves without access to courts individually before an arbitrator against the second largest multi-employer corporation in America, McDonald's, and that's the third, and the largest employer, Walmart, in the world, by yourself in an arbitration case. That's going to change. So I'm not just fueled by hope, I'm fueled by seeing results now.
I just want to add to that in terms of the fight for 15, and not just, as we know, the minimum wage has been stagnant at $7.25 since 2009, but at the local level, the state level, that's really where a lot of the action has been. And I think it goes to actually some of Dan's work in terms of this whole idea of, again, labor movements as political forces, right? So again, even when there is, the law is really against you, and again, I'm familiar with that in Las Vegas, we're a right-to-work state, and yet we have a very strong, active labor movement because, for exactly the same reasons that Judy said, they don't let the law stand in the way of organizing. So again, I think what that shows, or what the Las Vegas or the broader experience of the Fight for 15 movement shows, is that we're really talking now not just about employer labor management bargaining, but also this relationship with the government. Again, and I think we could talk about that in the public sector, but it is happening also in the private sector. The pressure that we're seeing in the Fight for 15 movement leading to changes at the local and state levels. So that's another phenomenon.
I just would say two things. First, the notion that you can get some kind of supplements to people's income depends on legislative action that results from some kind of pressure. And the notion that whether it's in the form of a more vibrant labor movement or whether it's in the form of some other type of collective action, you're going to get those results without pushing from that. It's just not going to happen. So the alternative is either you move down a path where the society becomes, more polarized between the haves and the have-nots, or some kind of organization that pushes back. And so whether it's inevitable to go one way or whether it's hopeful to hope for that, I leave to somebody else. But in terms of the results, you're not going to get benefit supplements and things like that without organized political pressure, and it's got to come from somewhere, even if it's not in the form of organizing labor organizations. The second thing is just to pick up on Judy's point about the Lewis case. We filed an amicus brief and appeared in that case, and we have 61 cases currently pending in the courts of appeals where the National Labor Relations Board has found an employer requirement as a condition of employment that people waive their right to proceed jointly and require single arbitration of fundamental employment rights to be a violation of the National Labor Relations Act, Section 8A1. We have 61 of those cases, and there is a split. Both the 8th and the 5th circuits have held that those type of agreements can be enforced pursuant to the FAA and disagreed with the board, the Federal Arbitration Act, and disagreed with the board. In Lewis, the 7th Circuit held that those provisions were a violation of the Act, and we're in every circuit but the 1st and the 10th. So even if it isn't Lewis, even if it isn't the lead case in the Fifth Circuit, which is a case called Murphy Oil, I think this issue is going to reach the Supreme Court at some point in the near future.
And if I could just add, when we were talking about going back to when there was a white working class men, was the parameters of how we viewed our success. I also think that is so changing in America. We're going to be non-majority white in,
Tomorrow.
Is it tomorrow? Okay. And, thank you. And right now, this weekend in Houston, 1,000 dreamers are meeting in their Congress for United We Dream. The immigrant justice movement is going to change also America. The immigrant workers came here to get a better life, and they are part of this movement. They will be there on the front lines of, working in solidarity with others. And so too the labor movement. At SEIU, we spend an enormous amount of effort and support on this question of the need for comprehensive immigration reform. Senator Klobuchar was so, important in what she said about that issue at lunch. And so really we're imagining again also a society where we're going to have to figure out in a democratic society what are the vehicles for engaging and for people getting a claim to not just corporate America deciding the distribution of wealth.
So we have 5 minutes left before we open it up for Q&A. So, and we frankly have been picking on Dan a little bit. So I'm going to join Dan for a minute and throw cold water on our other three panelists. And because Ruben, in particular, you just mentioned the wave of exciting, and Judy's been a part of this as well, the wave of exciting state and local-based efforts, successful efforts, starting in SeaTac and then Seattle and then Los Angeles, Chicago, New York, et cetera. So great, wonderful. Wages have been raised in many places, big cities in particular across the country. And that's, maybe we could argue that's a form of re-regulation that we talked about earlier. But there are a wave of state preemption laws that are coming right behind those efforts. So that's great, but they're about to all go away in a little bit. So how should we be thinking about preemption and those efforts, right, specifically to preempt the ability of states and locales to raise wages? And then secondly, I want to raise, and Judy, I know you've thought a lot about this, I'm thinking about this new model. I'm thinking about Uber and the gig economy, and Uber is being very aggressive. And its corporate strategy and political strategy of figuring out how to cut deals. There was something controversial around Airbnb. I won't mention any unions' names involved in that. Right? But there is a question around antitrust. And how might these alternative efforts to negotiate with employers run afoul of either the NLRA or antitrust? So can the three very positive folks on the panel, faithful and whatever we should call you, how should we deal with questions of preemption and questions of antitrust?
Well, I think I'll just start quickly about preemption. I mean, obviously it's going to vary depending on the state, and there's also, of course, all kinds of litigation in this regard. I think it's a broader symptom, of course, of the question of, when you have these movements, you still need, favorable laws. You still need, favorable, climates for them to exist in, and so it's going to vary, I think, depending on the state. But I think, again, the bottom line is that, what I think that the movement seems to be trying to do is to really try to make these rights sort of human rights, sort of basically say that there's a dignity of work, as we were talking about earlier, that these laws sort of aren't respecting, at least the preempting laws aren't respecting. And again, as we discussed earlier, it may be a multi-pronged strategy, but it may include some legal work and some more favorable laws to try and prevent sort of, and I mentioned this earlier in the beginning, there's this pendulum, there's this back and forth, and it really has to involve sort of a multi-pronged strategy that includes some some legal work that the left or the labor movement can't obviously cede to the other side.
On this preemption question, it's interesting, when we've been looking at it, this issue of preemption really grew very, as in the state realm, not federal versus state, but state versus local, with the gun control fight, where you had gun control ordinances moving in localities and gun regulation, and then states, in red states, moved to preempt those local ordinances. And now we have two interesting cases going on right now around this. And I thought the constitutional obligations panel earlier was just fascinating in this regard. In Alabama, Birmingham passed a wage ordinance to increase the minimum wage from $7.25, the federal amount, to $10.10. Birmingham is 75% African-American community, controlled by African-American council makeup. The state moved very rapidly in a special session to preempt that statute, and saying no statute could go on wage in localities to increase the minimum wage. We are supporting a lawsuit there by fast food workers, the NAACP, Alabama, to challenge that, to say that going back to the 1901 Constitution of Alabama, the issue of home rule that they are basing their action on was essentially a racial move to block localities that were controlled by African Americans to be able to better their situation and have the ability to govern themselves. And so we are challenging it as that they are basing it on a 1901 Constitution home rule analysis that is a violation of the Equal Protection Act. And it's an interesting case, but we believe that what the situation was there really points to the need to analyze what motivated that, and also what the really genesis was of the home rule provision in the 1901 Constitution, state constitution. We are also challenging and supporting litigation that is in Kansas City passed a wage ordinance. Missouri then preempted it. In this case, there's multiple cases going on challenging it on basis that these were done in ways that the state legislature acted so quickly that it did not follow the proper legislative policy about, I think they amended a statute that had to do with taxes on paper bags, and then all of a sudden said it was relevant and germane to also add in that, by the way, you can't increase the minimum wage locally. So those cases are going forward. But it is a difficult issue, and it really comes down to this basic fundamental debate in our country going on between the red states and the blue states about what our country is going to, the values that we have. If you look at Friedrichs, I urge people to go to the amici briefs that were filed in Friedrichs. 22 states filed on behalf of public sector bargaining to say this was important to them. Strong unions help them solve problems and work through issues in collective bargaining. 18 states said this is a disaster, and they actually state attorney generals were arguing against the constitutionality of their own state statutes, which I thought was not appropriate. But if you look at the lineup there, those are pretty much the same states that came down on the DAPA, defense of Obama's executive action extending the right of certain people to parents of children who are citizens to stay here, and expanding DACA in the Supreme Court. Again, about a flip, maybe the number's a little bit different, but most of the states line up on who supports that and who doesn't. So we really are very much engaged in a debate in this country, as we know, in the next several months, about where are we going in terms of our values. But you see it being played out now in our courts, and I really urge you to take a look at those Friedrichs amici briefs. They are really, on our side at least, they were very powerful arguments about what is the goal of collective bargaining in the public sector and the benefit to society as a whole.
So I know Dick wants to get in. If you have a question, please start lining up at the microphone. And I have to say, as a proponent of home rule authority, for Judy to just school us in terms of the origins of Alabama's home rule and Jim Crow, I now have to rethink my entire position on home rule authority.
Yeah,
Dick.
and I'm going to complicate it further because
Yeah.
I think preemption is a very tricky matter, and right now, the two preemption cases that we filed amicus briefs in are cases where localities in Illinois and Kentucky have passed right-to-work ordinances, and the state is not, neither of those states are right-to-work states, and the state attorney general has taken the position in both instances that the locality doesn't have the authority to adopt a local right-to-work ordinance, and we've filed amicus briefs saying, as a general matter, the National Labor Relations Act talks about states and territories adopting right-to-work laws, not, some subdivision thereof. So it's a tricky issue.
Okay, let's.
I was just going to
yeah,
say one
go-
thing to be positive.
Quickly,
for
yes,
just one
go for it,
second.
very
The
quickly.
line's long, so I'll be quick. But I was just going to say, when we think about Uber and the sharing economy, it strikes me that, what's the problem? The satisfaction among the drivers is high. We all as consumers love it. If DC were to ban, I can think the only cause of a potential revolution here in Washington today was if the city council banned Uber. Every Capitol Hill staffer would, go insane. I think that I'm not quite sure what the problem is with Uber. It's gotten mixed up in these bigger debates, but if you look at the numbers, 80% of Lyft drivers work less than 15 hours a week, 15%, or over 50% of Uber drivers work less than 10 hours a week. This is a part-time gig for a lot of people. It offers flexibility. I'm not sure that there's this big problem here. It's gotten hitched to a lot of other issues, but I've been yet to be persuaded that there's some great issue of labor concern here. There's some concern maybe about consumer protection, but that there's some issue of labor here, I'm less persuaded, but I'm open to
So public service announcement, my Uber driver just the other day gave me the password or the information for a new app called Juno in New York City, which classifies its workers as employees. And there's 30% off indefinitely.
So they can compete.
Yes. Okay, so let's take you in pairs. So I just have to ask, can you keep it short and brief? They'll take notes on your questions. And even if you don't really have a question, you need to say your statement in the form of a question. So short and in the form of a question.
Okay. Full disclosure, I'm Jason Walter. I'm senior counsel at NEA, and I was involved in the Friedrichs litigation. And I just didn't want the suggestion of organized labor as the kind of white guy protection racket hanging out there. And for people who are interested in learning more about that, there's a marvelous amicus brief that was filed on behalf of the National Women's Law Center and dozens of other civil rights organizations that talks about organized labor, particularly in the public sector, as being absolutely fundamental to creating a pathway to the middle class for African Americans, for other minority groups, protecting women, protecting LGBT workers, long before there were legal protections on the books for it.
Great, and the question
my question is,
great.
how you like them apples?
Okay, thank you. All right, next up. Well put. Please.
I'm Carolyn Poplin. I finished law school in 1972, so I remember very well the days when a manufacturing job was a good job because it was a union job, not because it was manufacturing. My question is, why is the Democratic Party ignoring unions? Even the PCCC, which I belong to, listed 15 issues. I mean, Sanders lists lots of issues, and nobody talks about unions. They talk about the minimum wage, and that's all well and good. But, excuse me, that's not going to do it. I gave up, so I became a physician.
Oh, smart woman. All right, let's just take a few more if the panel doesn't mind taking notes. Yes, please.
My name's Tarak. I'm currently a law student at USC. I was actually a Peggy Browning Fellow, so that's why I'm here.
Excellent.
So my question is about captive audience meetings. You know, captive audience meetings are things that we always fear the most as union organizers. We always feared it. It's a one-sided conversation between the boss and the workers. But there was recently a proposal out there to give equal time for union organizers to speak as well as the boss. So what do you think about the legality of that? Can that be potentially done? And just generally, like, comment on that. Thank you.
Great. So that question is, do property rights trump First Amendment? I'm paraphrasing in a sense.
Hi
Please.
there. I'm Nathan Kilbert. I'm an assistant general counsel with the Steelworkers, so I'm here from the Stone Age, actually. Professor DeSalvo made kind of a casual reference to a 2015 CBO study that suggested that increasing the minimum wage would result in hundreds of thousands of job losses. There's, of course, been a lot of pushback from that from progressive economists and various labor unions. I wonder if the rest of the folks on the panel think that it is, in fact, counterproductive to attempt to increase the minimum wage.
Great question.
you.
Let's just keep going. Do you mind? Let's do one more, and then we'll try to get you guys. Is that the end of the line? All right. Real quickly, let's take the rest of you. You're the last one, and then we'll have you, the super panel, respond to all of them.
Yeah, my name is Mark Zagira with the University of Houston. It's a general question. I was just curious what your thoughts were about the future of unionization or the prospects for unionization of adjunct professors, graduate students, people who are non-tenure track faculty and teachers at universities, particularly state universities.
Yep. Great question. Thank you. Yes, sir.
Hello, I'm Kenneth Simons. You briefly mentioned automation, and then you asked what's wrong with Uber. They're not quiet about them wanting to be completely autonomous. So my question is, what policies or potential laws are people thinking of to help keep humans working in the workforce as opposed to everything being automated?
Great question that no one will be able to answer in 30 seconds. But
And
last
this is
but not
going to be a
least.
short one. I'm just going to add to her question. And my question is, why do unions keep giving money to elect Democrats that keep ignoring unions?
Boom. Okay. Who wants to go first?
To start with that question and the question about politics, because I think it helps to also phrase a question in terms of what does labor hope to get out of, the Democrats or the politics, right? So historically, of course, we remember the coalition, the Roosevelt coalition, and that was, of course, positive legislation, by Democratic president, and so that's, as we know, the history of that. Then, of course, we entered the period of the 80s, and we entered the PATCO strike, and we know that that is another. Then we start to see, of course, the Democrats, and again, I think Dorian, as a political scientist, can talk about this as well. The Democrats seen, or the union seeing Democrats as more of a defensive move. So enter, of course, President Obama. Enter, as some of us, I actually, think about a lot, the early days of the Obama administration and the wish list that labor came up with in terms of the various things that we were hoping for, and of course they were dashed soon 2 years after, and so then obviously it gives us some lessons or some things to think about for the next administration, but I think it comes back to the fact, obviously, that in the last several years it's been more about defense, right? And so the question is really, why do unions give to Democrats? Defense, right? Defense, right? So that's one issue. Has the Democratic Party ignored unions, right? Has the Democratic Party abandoned the issues? And I think it all goes to the fundamental question about how, and I think we've talked about this before, how important labor law reform is to the next labor movement. And again, I think you can make a case, as has been done here, that even if we have to live, with no labor law reform, no change, as we have done the last 8 years, then we can still make progress in various ways. And I think that the idea that as some of you might remember, the Employee Free Choice Act, which would, died very early in the Obama administration, would have really changed the game, would have led to this boom of organizing. I mean, again, maybe we can think about how realistic that would have been even if we had it. So that's a good question for Dan, or a good thing for Dan to comment on. But I guess in the end, as I said, it all depends upon what labor wants from from Democrats, and sometimes, of course, labor just wants to be left alone. Like they wish the Republicans would leave them alone, like in many ways. And so that's, I think, what we're likely to see, the question we're likely to see in the next several months.
And so I just want to remind the three of you 90 seconds because the organizers want me to definitely end on time.
Okay.
So I would just say really briefly on this point, I agree with everything that Richard said, that on the political point, it's defense, but it's also there's nowhere else to go. In our two-party system, there aren't really other outlets, maybe a little bit here or there at the urban level. There's the Working Families Party in New York City and New York State, but that benefits from some oddities of election law in New York. So I think that's an important point, is there isn't another channel, and your complaint is also one that's been made for years, and many people have described the marriage between organized labor and the Democrats as a barren one.
I'm just going to stay away from the political question because I think it's been addressed, and I'm going to try and answer the two sort of more legal questions that were asked. One was about captive audience meetings. One of the difficulties with getting union organizer access to do the equivalent of a captive audience meeting is a case that was one of Justice Thomas's first opinions, the Lechmere decision, which limits the opportunities for access to fairly significantly. So that's would be an obstacle in terms of administrative law changes. Certainly if there was a statutory change, that's a whole nother question. The second thing I want to respond to in my 15 seconds left is the adjunct professor question. We have been seeing a lot of petitions from adjunct professors, and my impression, and this is completely anecdotal, is that the unions are winning those representation elections at a fairly high rate. So there's certainly no issue so long as the university or college is not a college that has what we would characterize as the Catholic bishops issue, which is the issue if they're related, if they somehow have a religious affiliation, that might make it a little more complicated. But otherwise, adjunct professors adjunct faculty seem to be organizing quite a bit through the National Labor Relations Board.
And to follow up on that, SEIU has Faculty Forward. If you go online, it is our adjunct organizing movement. We have been running a lot of elections that have been successful throughout in public and private sector. And it's really, frankly, the adjunct professors is part of our fight for 15 because, the reports that are coming down is they are not making $15 an hour when you divide up all the amount of work that they put into preparing for their work. The report from George Miller's Labor Relations Subcommittee was that the average wage for adjunct professors was $23,000 a year with PhDs. So this is really, they've been a really telling story about what is happening in our economy, that it's not just about get a better education, but it's about how a lot of the access and ability to bargain decent wages and conditions, working conditions, are affecting everyone. And they've been a really important part of the campaign. Uber. It's interesting because Uber, one of the reasons why the lawyer who settled the big case recently in Massachusetts and California said one of the reasons she was pressed into settlement was the challenge of the mandatory arbitration provision in many of the Uber drivers' contracts. And, that's going to change now. And the question is really, what is the difference? If you can run Juno, is it that technologically you can figure out all this platform, but you can't figure out how to actually have somebody put a card in as a driver, say I'm on now and I'm as an employee, I'm on the ticket now and now I'm off the employment payroll. They actually are able to do this in McDonald's because guess what? Those workers do not get to work, even if they wanted to, a regular 8-hour day. A lot of workers these days, like McDonald's workers, are put in there 4 hours they're off the clock. If not enough people come in and ask for burgers, guess what? You're walking for the rest of the day. So it's not like everybody else is working stable hours. People are working all kinds of hours, and they figure you know it's technologically capable. I would think if they can figure out all this other fancy stuff, how to log people in to pay their workers' comp and unemployment comp insurance and their Social Security benefits. You know, how hard is that? So that was my answer to Uber. On Democratic, and I would just say though, on gig economy, SEIU is not of the mind that all gig economy employers have to be, gig economy work has to be classified as traditional employment situation. Each one has to be analyzed on its own terms and decided, you know, what is this and how best to organize collective power. Democratic Party, we've endorsed Hillary Clinton, and frankly, we think she will be good for unions. We think, more importantly, she will be good for working people. And she is loved by home care workers, child care workers, janitors, people who she's met with throughout the primaries and talked to because she is committed to their issues. So I feel very comfortable, frankly, being part of the establishment in the sense of supporting the Democratic Party this year and supporting Hillary Clinton, because it's going to make an enormous difference to have a woman in the White House who is committed to the value of work of women and committed, I believe, to labor unions as part of that society setup.
And on the question of robots, we're going to have to rethink the entire way we organize work and leisure, which is a radical proposition that I can't go into now because I have to end. So please join me in thanking Dick, Ruben, Dan, and Judy.